My Lords, I shall be sharing the presentation of the NHS's case with my learned junior, Mr. Drake. With your Lordship's permission, I will be dealing with the NHS's response to the grounds of appeal brought by the pharma companies, and Mr. Drake will deal with our respondent's notice.
Okay.
A couple of minor housekeeping points. There is a mistake in our skeleton argument, which occurs on a number of occasions, of the 21st of March as the 2021 as the date of the Court of Justice, this final decision in the Lundbeck appeals. It isn't, it's the 25th of March.
Yeah.
And the anniversaries of that are sometimes misstated as the 21st of March. Again, it should be the 25th. I apologize for that. We simply didn't pick it up. The second housekeeping point, my learned friend took you to the version of Section 47A of the Competition Act 1998 at tab 19. Actually, the version that was in force at all material times, as from October 2015, is the version at tab 22. We may come to that in due course.
Yeah, I did wonder about that, fair enough.
But in case...
It's the one that's Schedule 8 or whatever.
It's not Schedule 8, exactly, my Lord.
Yeah.
It probably doesn't make a difference, but for purposes of your Lordship's judgment, your Lordships will obviously want to get it right.
Yeah.
So I shall start by dealing with the main element of the pharma company's case, namely that this claim form does not count under Rule 30 of the new 2015 rules, and under Rule 31 of the old rules as preserved by Rule 119 of the new rules. And that claim is made despite the admitted fact that the claim form was filed within the preserved Section 47A limitation period that was at that time as agreed between the parties, available to the NHS. I'll then deal with the estoppel case. My Lords, when I opened this case before the tribunal last year, I said that the key to this case was to remember the well-known aphorism that if something looks like a duck, walks like a duck, and quacks like a duck, then it is usually safe to conclude that it is a duck. In the context of this case, if a document looks like a claim under Rule 30 of the tribunal rules, complies with all the formal and substantive requirements that that rule sets out in order for a claim to be made, is filed in the way that that rule requires in order for a claim to be made, then in our summation, it is a claim form under that rule and is made by virtue of and under that rule. Now I'm going to start by a rather important document that we've scarcely been to, which is the claim form itself. And I'm going to invite the court to look at the amended claim form. Now all the points I'm going to make apply equally to the original one. And the amended one is in the core bundle at tab 21, starting at page 365. And if I can also invite your Lordships to have open Rule 30, which is in the authorities bundle, tab 23, page 558. Your Lordships will see the requirements of Rule 30.
Sorry, give me that page.
Yes, so the Rule 30 is at the authorities bundle, tab 23, page 558.
Yeah, thank you.
The amended claim form, which is the one I'm going to, is in the core bundle, tab 21, starting at page 365.
Yeah.
Now, your Lordships will see in Rule 30 that the claim form, this is paragraph 2 of Rule 30, shall state the full name and address of the claimant, claimant's legal representatives, address for service, name and address of the defendant. So that is all done at pages 366 to 370, your Lordships will see. By Rule 30, sub 3A, it's required to state whether it is made in respect of an infringement decision, and if so, whether that decision has become final. And your Lordships will see that that is done in some detail at pages 374 to 377.
You've already told us that it's common ground that all these are complied with.
Yes, I'm just making, I think if, there are various points I want to make about the claim form.
Sure.
Yes, I mean,
Okay.
yes, but if I can take, India, I'll take it very swiftly, but while we're here, we're going to make a couple of points that are important I want to make, which one sees in the claim form. First of all, if one looks at paragraph 1 on page 374, that expressly states that it is a follow-on claim for damages pursued to breach of statutory duty under Section 47A of the Competition Act 1998. Now, of course, a claim under Section 47A of the Competition Act can only be brought in a tribunal. It could not be brought in the High Court. And as your lordships saw the High Court claim form, which we went to, my learned friend took your lordships to this morning, at the supplementary bundle, page 36, tab 5, that claim form makes no reference whatsoever to Section 47A and is a pure breach of statutory duty claim on the basis of the Treaty on the Functioning of the European Union and the Competition Act 1998. It also, incidentally, the High Court claim makes a claim of breach of Article 102 of the Treaty, abuse of dominant position. That is not made here because this claim form falls squarely within the infringement decision of the Commission. And the Commission made no findings under Article 102, it was all under 101. And of course, it made no findings under the Competition Act 1998 because it couldn't, as the European Commission. Its findings are entirely on the basis of the treaty. And again, that is the basis of this claim form, which is confined to a claim under the treaty. Then, if your lordships notice at paragraph 13, which is on page 376, starting there, it's made clear there that the claim is made relying on the limitation period, the preserved limitation period for Rule 40, Section 47A claims, and the decision
It's
that
the
is in
13,
question
Rule
tonight.
31. So I mean that's expressly
It's
setting out
expressly set out that we're
period
relying
of
on that limitation period.
Yeah.
And then paragraph 14, you will see, makes detailed submission as to the effect of that limitation period.
Yeah.
Then, forgive me, my lords, just one more point just showing compliance, but it again takes me to an important point. Rule 30 also requires the claim form to contain observations on which part of the United Kingdom the proceedings of the tribunal are to be taken place in. Is it England, Wales, and Scotland? Is it Northern Ireland? That is done at paragraph 16 on pages 377 to 378, and also at paragraph 47, which is at page 389.
Yeah.
And I invite your lordship to go there because it is there that one finds what I think are the only references at all in this document to the High Court proceedings. And that's at 47.6 on page 390, which makes the point that there were proceedings originally issued in the High Court of England and Wales. This is in the context of explaining why England and Wales is the appropriate jurisdiction. And that refers to a previous statement, but there I think the reference is to 45.1, which is to a reference to the order of Deputy Master Linwood transferring the proceedings. Now, I've done a detailed search, I think. I was using search terms of this document. I am pretty sure there is no other reference in this document to the transfer proceedings, apart from the letter T at the top. That is it. In all other respects, this is, if one was reading this completely cold, one would imagine that this was a claim form completely afresh. The only reminder or reference to the background is in that provision, in those paragraphs, and which are more or less sort of side comments in the course of making submissions about jurisdiction.
If your clients had taken the course of abandoning the High Court proceedings and issuing a as it were, fresh claim in the CAT, other than there being no need to put the T in, you'd almost certainly have included these two paragraphs by reference to the background, as it were, to what was going on.
Absolutely, my
Certainly
lord.
would refer to the fact that it started in the High Court.
Indeed, and that, but the point of those paragraphs being to say this is the appropriate England and Wales, and one of the reasons why is because the story started in England and Wales. Absolutely, and that is it. That's the only otherwise, it's really impossible to see in what respect this document would have been any different had we served it de novo. And certainly we say neither of those stray indicia can displace the clear and repeated statement in the claim form that it is making a Section 47A claim, which is incontestably a different claim from that made in the previous High Court, because Section 47A claim could not be made in the High Court. So what the, and I go through the other formal requirements of Rule 30, but I think it's common ground that they are all met in this case.
How does it work? My understanding from the rules is that you send the claim form to the registrar.
Yes.
So how do you get the case number?
Well, one can see actually the number here was allocated, I think the document is in the supplemental bundle, yes, it's at tab,
Supplementary.
I think it's in the supplementary bundle. There's a letter from the CAT registry. Yeah, the 10th of, yes, I found it. It's in tab 19 of the supplemental bundle, page 95. And your lordships will see there's a letter from the CAT registry. So unsurprisingly, the allocation of a case number is an administrative act. One can see this is the registry, but signed by Mr. McGivney for the registrar. So it's an administrative act to allocate a case number, and the case number is allocated. You'll see the case number is given in the heading, and if you cast your couple of paragraphs down, it says this case has been registered under the case number set out above, which should be quoted in all correspondence with the tribunal.
Yeah.
So that's where the case number comes from. And unsurprisingly, given that one wants to make sure that the CAT dealt with the claim form correctly and put it in the correct file, that is presumably an explanation as to why the reference number was put on the top on the basis that was the number the CAT had given it.
So the Competition Appeal Tribunal regarded the filing of a claim form as being in accordance with Rule 30.
Yes, sorry, I put that letter away.
Page 95.
Third paragraph down.
Yes, let me find it. Yeah.
In accordance with Rule 30.
Yes. Yes, it is noted that the claimants intend to file a claim form with the tribunal in accordance with Rule 30 and propose to add Ranbaxy. Yes. Yes.
Yeah.
So what the pharmaceutical companies are essentially submitting is that despite the admitted full compliance of the claim form with the requirements of Rule 30 for a claim to be made, and despite the admitted fact that it was filed within the preserved Section 47A period, and despite the fact that the claim form itself says that it's a Section 47A claim filed within the Section 47A claim period, it does not count. And the reasons why they say it doesn't count are ones that have nothing to do with the content of the claim form or with the way in which it was filed. Rather, those reasons relate to their interpretation of the background history of the matter, and possibly, it appears at some point, with the way in which the parties may have understood the claim form. And a sort of headline point is that in the context of limitation rules, where legal certainty and clarity are of some importance, we say that the question of whether a claim has been brought within an admittedly applicable limitation period ought to be one capable of being answered by looking at the document sent to amount to the claim and to the circumstances of its filing. Does it comply with the requirements? Has it been filed or served correctly according to the relevant rules? It should not depend on a detailed inquiry into the history of previous or ongoing litigation. So in our submission, the pharma company's claim that it does so depend should be approached with some scepticism. And in any event, for the reasons it does not work. Before coming to those reasons, I should clear some ground by disposing of large parts of the pharma company's submissions which simply mischaracterize the position. This is not, as my Lord the Chancellor pointed out right at the outset, this is not a case where the NHS is seeking to resurrect, to use my learned friend's word, a time-barred claim. We accept the High Court claim started in 2019 was time-barred. We're not seeking to revive that claim, which was not a claim brought under Section 47A and included elements such as a claim to breach of Article 102 and a breach of the Competition Act 1998 that we are not seeking to proceed with. Rather, the claim, as the claim form itself says, what the NHS is seeking to do, or rather what it actually did in February and early March 2023, was to make precisely the Section 47A claim that it was, as the pharma companies admit, entitled to bring at that time in reliance on the preserved Section 47A limitation period, which did not expire until the 25th of March 2023. Nor, to find in which my learned friend mischaracterises the position, are we trying to apply the preserved 47A limitation period to the transferred claim. The claim form is clear on this. Unlike, as I said, unlike the transferred claim, which is not a Section 47A claim, this is a claim based on Section 47A, and it relies on those time limits. Nor are we suggesting, at least so far as our primary concern is concerned and subject to our respondents' notice, we are not suggesting that the transfer of a claim from the High Court to the CAT could of itself affect the application of the limitation rules or make a claim that was out of time when transferred in time. Indeed, our case is far simpler. Indeed, one's tempted to say one that falls into the Sybil faulty category of stating the adjective obvious. That is, that it's the finding of a claim meeting the requirements of Rule 30 is made for the purpose of that rule, and it amounts to the making of a Section 47A claim for the purposes of the preserved Section 47A limitation rules, and that is precisely what we did. Now, I break my submissions on the substance of this into two headings. One is interpretation of the rules, and one is what we submit to the rather obscure distinctions that my learned friend's case leads to. So first on interpretation of the rules. We've looked at Rule 30, which tells you how a claim is made, and it's made by finding a claim form that complies with the Rule 30 requirements. That's what Rule 30 says. If one then looks at Rule 119, which I've been to several times before, but it's at tab 23 of the authorities bundle, at page 569, as my learned friend accepts, this claim falls within subparagraph 3. It's a claim to which Section 47A applies, and it arose before the 1st of October 2015. So one then goes to paragraph 2. So the limitation period continues to apply in respect of a claim falling within paragraph 3 for the purposes of determining the limitation or prescriptive period, which would apply in respect of the claim if it were to be made on or after the 1st of December 2015. What does made mean? Well, made is what Rule 30 tells you it means. A claim is made when it's filed and it complies with the provisions of Rule 30. Simple as that. And here the claim was made on or after the 1st of October 2015. It was made in proceedings under Section 47A of the 1998 Act. It was made in the CAT, and it says in terms it's made in proceedings under Section 47A, and therefore it satisfies the requirements of Rule 2, paragraph 2. And then finally, of course, Rule 31.1, which is the preserved rule, it must be made within 2 years of the relevant date, and it's common ground that the dates on which it were filed in February and early March 2023 were within 2 years of the relevant date, which is the 25th of March 2021. And there is, we submit, nothing in the concept of made, the key verb, that suggests that a claim cannot be made simply because a parallel claim has already been made or there are ongoing proceedings. A claim can be made again. A vexatious litigant may make 3 identical claims against the same person on 3 successive days. Now, those claims may be disposed of in short order, but that does not mean that the second 2 were not made. They were made. It's just that making them is likely to be abusive process, leading them to be struck out. What, in our submission, Ms. Ford's submissions are effectively doing is to look at all of this through the wrong end of the telescope, which I think is a way of putting the point put to my learned friend by my Lord Justice Phillips. Instead of adopting what we say is a common sense approach of starting with the text of Rule 30, seeing what Rule 30 says amounts to the making of a claim form and taking it from there, what she does is she starts with the proposition that made must mean commenced, and then she says, well, since this is not a fresh claim, it can't have been commenced, and therefore can't have been made, whatever Rule 30 says. But when you look at this through the right end of the telescope, you see that the debate about whether made means commenced is in reality really rather beside the point. Whatever made means, whether it means commenced or not, Rule 30 tells you that if a claim form ticks the various boxes in Rule 30 and is filed according to the provisions of Rule 30, then it is made. It doesn't really matter whether made means commenced or not. It is made. And it then follows that once a claim is made, Rule 119 and 31 then apply, and in this particular case, that means that the claim was made within the preserved Section 47A limitation rules. Put another way, if made means commenced, then all that means is that by filing a Rule 30 claim form, we commenced proceedings, which effectively is the approach taken by the tribunal. It said, well, so what? If that's right, then we accept, this is paragraph 46 of the tribunal's judgment, which we've looked at this morning, then proceedings were commenced.
Yeah.
And we did what was necessary to commence them. And by commencing them at the time that we did what we needed to do to defeat a limitation defence under Rules 119 and 31.
Yeah.
And we entirely agree with the tribunal's reasoning. But even if, and I mean, accept my learned friend is right to say that the tribunal did not find that there were duplicative proceedings. It said, well, you can commence proceedings even if, and it can also be the continuation of existing proceedings. But even if the defendants, even if that's not right, and even if commenced necessarily means that one must be starting fresh proceedings, well, that means that our cases, the consequence of Rule 30 is that the claim form started duplicative proceedings. Well, that's what it did, if that's right. And there's nothing strange about the idea that the claim form commenced duplicative proceedings. It happens all the time. Indeed, in a very similar context, it's worth looking at the Deutsche Bahn case, to which my learned friend took you briefly this morning, which is at Authorities Tab 8 at page 182.
Yeah.
And if you look at, just give me a moment. If your lordships look at page 184, paragraph 4, your lordships will see that High Court proceedings have been brought by various claimants against MasterCard in 2012 and 2013, and that limitation defences were then raised to those. And then at paragraph 5, we're told that the claimants then started a claim in the tribunal as a protective measure. And it's clear from the final sentence of that that the CAT proceedings were essentially a subset of the High Court proceedings. The High Court proceedings overlap with the CAT claim, but are significantly more extensive in scope. So the CAT proceedings are a subset of the High Court proceedings. And MasterCard then claimed that the tribunal had no jurisdiction to hear the second parallel claim, alternatively that it was an abusive process. And that's what the main issue with which the tribunal was grappling with, starting from page 109 on abuse of process. But if your lordships just glance quickly through paragraphs 31 to around 34 on pages 193 to 194, your lordships will see that the tribunal did not consider that it was necessarily an abusive process, while one claim is still running, to start another claim identical to or overlapping with the first claim, and to do so for limitation reasons. And if I can pick it up at paragraph 35, the tribunal cites the judgment of Mr. Justice Arnold in Activis, and your lordships will see that in that paragraph, Mr. Justice Arnold says it is not an abuse of process to bring a further claim on the same cause of action during the pendency of an existing claim if there is good reason to do so, and case management tools like consolidation are used to avoid unnecessary duplication. Now, I mean, it follows, I mean, all that is saying, all I need your lordships to take from that, we're not, of course, arguing about abuse of process, but the abuse of process argument proceeds on the unstated but fairly obvious basis that it is possible to make a duplicative claim. It's the point I was making earlier about the vexatious litigant. But there are circumstances where it's not vexatious at all. It's an entirely appropriate course of action to bring a duplicative claim, for example, to protect one's position in limitation. So there's nothing surprising about the proposition that this claim form is a duplicative claim. It may be, if that's not surprising or objectionable. So even if made means commenced, as my learned friend is so anxious to persuade your lordships that it does, and even if commenced means that one has to accept that the claim form started fresh proceedings, well, so be it. That's what it did.
Yeah.
And the reality is that had the defendants not decided to take the present limitation point, presumably, if that's right, nobody would ever have noticed that that's what had happened. And if some diligent or pedantic lawyer had pointed out that the effect of the claim form was to commence new proceedings, the reaction would no doubt have been a weary sigh, followed by an order to consolidate the proceedings or to strike out transferred proceedings to the extent that they still existed as merely duplicative. Now, Ms. Ford tells us at paragraph 24 of her skeleton, which is at page 154 of the core bundle, that it is clear that the claim form did not give rise to a duplicative claim. Now, I'm afraid there that it is clear as its usual meaning in legal submission, so I would like to assert this but can't show it. And though my learned friend relies on what she says is the tribunal ruling that possibility out, and she cites paragraphs 43 and 46, to which we've already gone to, the reality is that those paragraphs do not grapple with the proposition that the claim form gave rise to a duplicative claim. They simply proceed on the perfectly satisfactory basis that the claim form continued the High Court proceedings without discussing that other way of approaching the matter at all, because they didn't need to. Now, as it happens, we don't think the defendants are right in arguing that the reference in Rule 119 to a claim being made should be read as if it said commenced, and you have our detailed argument on that, paragraph 24 of the skeleton. There's the debate to which my learned friend refers about the extent to which one can rely on headings in order to interpret a statutory provision. My learned friend took you to Bennion, a passage that she did not read to you on Bennion, so page 584 of 25 of the authorities bundle, is a statement in that paragraph that quotes, "It is most unlikely to be right to allow the plain meaning of the words to be overridden purely by reason of a heading," close quotes, i.e. it's only in the cases of ambiguity that one has regard to the heading, and we say the provision is not ambiguous. But as I said, the fact is that all of this debate is somewhat sterile, because even if the pharma companies are right about that made means commenced, the point gets them nowhere. And indeed, that's what the tribunal held at paragraph 46 of its judgment. Now I get to my second point, which I've headlined obscure distinctions. And I think your lordships have, in a sense, already got there. The defendants accept, as they have to, that it would have been open to the NHS to bring a Section 47A claim at any time between the 25th of March 2021 and 25th of March 2023. And such a claim would have had to be brought by a claim form filed in the tribunal. Defendants have never suggested that there is any respect in which the claim form actually filed did not comply with the requirements set out in Rule 30, or that there was any defect in filing. So we have had no account from them of any respect in which the drafting of a claim form that would, in their view, have worked would have been any different from the drafting of the claim that was actually filed. So on the defendant's case, there is some mystery ingredient missing, extraneous materials, my Lord Justice Green put it this morning, from the claim form as actually filed, which has the effect of their submission of making it ineffective for limitation purposes. And that mystery ingredient is not to do with the drafting of the claim or the manner in which it was filed. So what is it? Or put a more colloquial way, what is it that the pharma companies say that we ought to have done, but which we did not do, but if which we had done it, would have made this claim form effective? Now, I've had the pleasure of reading 2 skeletons drafted by Ms. Ford and having heard her on 2 separate occasions, but I'm still somewhat in the dark as to what that question is. Is it her case that the missing ingredient is that we did not terminate the transfer?
I think that's the point.
I think that may be.
The missing ingredient, as you put it, is that you didn't discontinue the...
I think that's where she was being
Pay the
pushed to,
costs.
around 11:20 this morning, I think, according to my note, when she was dealing with questioning from you, my Lord, and from Lord Justice Green about the Sainsbury's case. But the problem with that way of putting it is it suffers from the problem that, as I've already pointed out, there's no rule that makes it impossible for you to start new proceedings, even when you have brought proceedings covering precisely the same issue and which are still ongoing. Now, second proceedings might get struck out for abuse of process, but that's a different question. So it's, in our submission, entirely unclear why that is a relevant distinction. Presumably not.
Maybe it's also that there's no rule that an existing proceeding cannot amount to a validly constituted claim form under Rule 30. I mean, either the claim form was a new one, or it was an existing one which was treated by the rules as a claim form under Rule 30.
Yes.
And if it wasn't under the rules, that doesn't render the proceedings an irregularity.
No.
No.
One law says that the issue, if in effect, turning it the other way around, the issue of the claim form, by issuing the claim form, you make the claim.
Yes.
And doesn't say, except in cases where there's been a transfer in from the High Court.
Indeed. Indeed. The reference, my Lord, the reference to irregularity reminds you, your Lordship was, my Lord Justice Green was has referred several times to a rule of the tribunal on irregularities. It's Rule 114. It might be helpful if your Lordship should have a copy of it. It's been referred to several times.
I'm just wondering what an irregularity is. I mean, that might be a...
Yes, I don't
think you could say, if there was no limitation, if you were outside of time, I don't think you can cure a substantive defence as an irregularity, but if this was said to be defective for some procedural failing because you haven't terminated prior proceedings, is that an irregularity?
Might be all that we'd mistakenly added a T at the end of the claim form.
Depends what's meant by T.
It depends.
T could simply mean historically it's been transferred.
Indeed.
Or it doesn't necessarily mean it's a continued claim.
No, one assumes that's what it meant.
So has there been a failure to comply with the provision of the rules? So
Yes.
here it would be a failure to comply with Rule 30 because you haven't extinguished the prior High Court claim.
And that might indeed. But I mean, in our submission, there's nothing irregular about that in any event.
No. Well, if it is irregular,
And then
the
if it's
question is,
irregular,
then what's the consequences?
indeed.
Yeah.
It's presumably not a case, and I don't think it is, to be fair, that anything turns on what the NHS or her clients indeed understood to be the effect of the claim under Rule 30. And of course, your Lordships, and as did the Tribunal, has no evidence whatsoever about what the parties subjectively thought was happening. It's entirely, one has to rely on the contents of the documents.
Yeah.
To judge to the extent that it's relevant, what the intent of the parties was. And if one looks at the claim form, well, it's constantly referring to Section 47A, and it says it's filed within the Section 47A time limit. So that looks like our intention. My learned friend did refer several times to what she claimed to be a procedural happenstance. as a meaning it didn't count. But to put it generally, it's hard to see any principled basis behind that approach to the rules. How does she define a procedural happenstance? I mean, in a sense, whether a claim form was filed in time or not is always a procedural happenstance. I mean, if a solicitor charged with filing a claim on the last day of a limitation period runs down the stairs to get the tube and falls down and misses the tube, and as a result the document doesn't arrive in time, that's a happenstance, but it clearly affects whether the limitation period has been complied with or not.
Yeah.
So in that sense, well, yes, I mean, limitation to an extent always does depend on happenstances.
Yeah.
So that's not a criticism. But if she's trying to make some point behind that, it's entirely obscure to us what she means by a procedural happenstance. As to leaving off, and I think at about 11:45 this morning, she suggested that what we should have done was left the T off in the heading to the claim form. But in that context, one is reminded of the famous comment by Gibbon about the theological debates of the Byzantine Empire, where he points out that it's extraordinary that so much blood was spilt by dispute as to the addition of a single iota to a critical word of the creedal formula. In the creed, it is incredible that the addition or not of this extra letter can have any consequence of the real world. And we've already made the point that it could be dealt with in any event.
Who placed the T on it? Was that something done by the registry?
That was done by the registry. As I went to earlier,
It was a number that they gave.
It's a number that they gave. Yeah, indeed. And I emphasise it by an administrative act. It's no judicial act putting the T on. It's an act of the registry.
And that was actually done before the claim form was issued, because the claim form wasn't actually
the claim form was
issued until nearly 2 years
until
later.
some time later. Yes. Yes.
Both the transfer proceedings and the claim form have the same number. So
Yes.
it seems like there is just one claim.
Yes. Well, I think I would. One doesn't want. I think I would cautious. I would urge some caution in interpreting too much significance given to the putting of a particular number at the top of the claim
No,
form.
I mean, every claim has a number.
Yes,
But there's only one claim number. And on the face of it, there's only one claim.
well, the claim number, of course, assists the court's administration to make sure that when the claim arrives, it's put in the right file. But if it's urged that in some way by putting that claim number on the form, the defendants, the NHS was in some way sort of contradicting what is elsewhere expressly set out in the form, that it's a claim form under Section 47A made relying on the Section 47A limitation period. That can't be right.
I don't see that is the consequence. I just think insofar as one is trying to identify what actually happened,
Yeah.
it does seem as though the claim form was issued and certainly regarded as being part of or embodying in the transferred proceedings. Otherwise, why would you use the same claim number?
That might be a conclusion as to what the NHS might have thought that it was doing, or even what the registry thought was happening. It's not, in my submission, doesn't actually tell you, it's not it doesn't conclusively answer the question as to what the effect of the claim form actually is, which must be judged by reading the claim form as a whole and not by the reference number. And if the analysis of the claim form is as a whole leads the court to the conclusion that it is effectively starting new proceedings to the extent that that question is relevant, then that's a conclusion the court can and should come to without being disturbed by the claim number at the top, which is essentially a matter of administrative detail.
You.
So that's that, as I said, made the point that it's somewhat obscure. The pharma companies say that we should have done that we didn't do, apart from terminating the proceedings. I now turn to the pharma company's submission that our position leads to what they call arbitrary consequences, and the arbitrary consequences claim is posited. The what my learned friend does is she posits a claim made just in time under the 6-year limitation act period, but more than 2 years after the relevant public authority decision, and there's no appeal from that decision. And she posits High Court claim is brought, swiftly transferred to the tribunal with a direction that a claim form be filed in lieu of particulars of claim. And she complains that in those circumstances, the effect of our argument would be that by reason of the service of the claim form, an in-time claim would be transformed into an out-of-time claim. But that objection fails, and we say fairly obviously fails. I mean, the first reason is that in such a case, it is inconceivable that the claim form would state that it was making a Section 47A claim relying on the preserved Section 47A time limit. After all, on that basis, it would be plainly out of time. Rather, the claim form will be drafted in such a way as to assert that it is no more than a step in the transferred proceedings. So we're doing something quite different from what the actual claim form in this case does. And to the extent that even in those circumstances, it might be said that the claim form would have the effect of starting out of time Section 47A proceedings, there's no reason why that should affect the fact that the transfer proceedings still subsist and were brought in time.
Well, I suppose you might say, well, unless the claimants were, as it were, asleep at the wheel, then they wouldn't transfer the proceedings at all,
Quite.
unless they procured from the defendants an undertaking not to take a limitation point
Indeed.
of about a 2-year period.
Indeed.
Otherwise, they just say we're going to leave it in the High Court.
Indeed. And with all due respect to my learned friend, this is not a real world example. I now move on to deal with the Sainsbury's judgment, which is at tab 5 of the authorities manual, page 44. Now, as your lordships have already spotted, the background of this judgment was that concerns had been expressed by solicitors for claimants that the effect of the transfer to the tribunal could potentially be that under the Section 47A limitation rules applied to proceedings of the tribunal, there could be an argument that once they got to the tribunal, there could be an argument that the transferred proceedings would be out of time. And Mr. Justice Barling, understandably, wanted to give some comfort to those parties, which is perhaps a tactful way of putting, in the words of my Lord Justice Green, the heavens forfend point. And he did so apparently without hearing any significant argument on the point. In particular, and critically, Mr. Justice Barling did not consider, because it was not relevant and he was not invited to consider, what the effect would be of any claim form that would be served in the context of the transferred proceedings. Now, if we go to paragraph 29 on page 148, the learned judge found a number of reasons why Rule 119 did not apply to the case before him. The first was that the proceedings were, for him were brought before the 1st of October 2015. That reason obviously doesn't apply here. The second reason was that the transferred proceedings were not a claim made in the proceedings under Section 47A. That is obviously true of the transferred proceedings, but is not true of the claim form in this case, which expressly refers to Section 47A and is brought in proceedings under Section 47A. The third reason, which is foreshadowed a bit in paragraph 27, is that Rule 31 applied only to claims originating, the verb the learned judge uses, originating in the tribunal. Now, originating is of course not the statutory language, and we assume it's not intended to be a gloss on the statutory language, and therefore shouldn't be taken to be anything more than a proxy for the statutory language, which is of course made or make. That verb is the critical one. And for the reasons I have explained, here the claim form does make, or to use Mr. Justice Barling's term, originate, a claim in the tribunal. So for our purposes, Sainsbury's is simply distinguishable, and the tribunal were entirely right to distinguish it, quite apart from the point that the issues weren't fully argued, as far as one could tell, before the learned judge. So those, my lords, are my submissions on the first ground of appeal. I now come to the question of estoppel. And on that, as is common ground, and there are authorities for this cited at our skeleton. We went to the passage in Chitty. This essentially boils down to the question of whether the parties agreed in the transfer order, it is agreed is to be approached on the basis that it is a contract between the parties, that the NHS would not argue that a claim form filed by it in the circumstances of this case had the effect of making a Section 47A claim within the preserved Section 47A period. By way of a slight digression, my Lord Justice Green said that a consent order could be registrable under the Restricted Trade Practices Act, as I am perhaps one of the few, along with my Lord, one of the few people old enough in this room to remember the RTPA. Indeed, I spent my first 5 years as a lawyer at the OFT advising on the administration of it. He's absolutely right on that. That is true.
Topless and Gessie, was it?
I think so, yes. I couldn't remember. Trying to do, I thought I had better things to do, frankly, in my lunch hour than research case law on the RTPA, which is not these days that easy. The assumed basis of this argument, of course, is that the pharma companies have lost on their first point, and that absent the terms of the transfer order, the NHS would succeed on that argument. So that inevitably means that what the pharma companies are arguing is that the transfer order had the effect of excluding or limiting a right that, on the assumption that for the purposes of this stage of their argument they accept, that the NHS would otherwise have had. And that, of course, that calls into play the authorities cited by the tribunal at paragraph 61 of its judgment, the Cape Bari and the Stocznia Gdynia cases, to the effect that very clear words are required to have the effect of qualifying or limiting valuable rights. And the transfer order also has to be read against the admitted background that as of July 2021, and whatever the position on limitation in relation to the claim was brought before the High Court in 2019, the NHS had a right to bring Section 47A proceedings before the CAT, which would at that point, and up until the 25th of March 2023, be in time under the preserved Section 47A rules. And the pharma companies were not, and do not claim to have been, under any misapprehension as to that reality. And against that background, the pharma company's claim of a contractual bar suffers from two basic flaws. First, there's no clear wording to that effect, and clear wording is required to qualify the NHS's rights. And second, to the extent that this provision is said to be implied into the contractual wording, it's impossible to see what the commercial purpose justifying the assertion of necessary implication of such a bar would have been, because the wording, whatever wording it is that the pharma company is suggesting, it could not have protected them against a Section 47A claim being brought, because that was always and admittedly open to the NHS, whatever the effect of the transfer order. Indeed, one can't help but observe that had the pharma companies wanted to be clear on their point, and had they proposed wording expressly making the provision for which they contend, something to the effect that you cannot rely for limitation purposes on any claim form filed in what could be said to be a continuation of these proceedings, some wording of that kind. The effect of such a proposal would have been to put the NHS on notice that the pharma companies were holding the argument that they are now making in reserve, and would have led the NHS either to reject the proposed wording or to abandon the transfer order and simply start again in the CAT. And this is perhaps a way of putting what I think my Lord Justice Phillips referred to as the gotcha point, that it is a point in the end about the commercial reality of what the pharma companies are suggesting.
Well, the second ground proceeds on the assumption, as you said, that the first ground is not successful. So it must be the case on this premise that the claim form does make a claim under Rule 30, which then qualifies for a 2-year period. So what is being agreed, as alleged, is incredibly narrow.
Indeed.
It's saying that we're not preserving a defence but we are preserving the right for you not to do it this specific way.
Well, quite. And what is the commercial purpose of that? I mean, one can't see any commercial
How
purpose
can you
in that.
possibly construe an agreement to have that meaning?
Indeed. Indeed, absolutely. I entirely agree.
Yeah.
Now, the defendant suggests that the principle that it requires clear words to qualify valuable rights and remedies somehow applies in their favour on the basis that the NHS's ability to bring Section 47A proceedings affects their rights. But the problem with that is the obvious one, that as of July 2021, they had no valuable right not to have Section 47A proceedings brought against them, either de novo or once it got to the CAT as the continuation of High Court proceedings. I mean, to put it, the champagne was still on ice in July 2021, and it would remain on ice for another 2 years of clenched knuckles and anxious clock watching while they waited for the Section 47A limitation period to pass by. But as of July 2021, there were no accrued rights whatsoever. Now, if I could just turn to the wording of the transfer order, we made those sort of preliminary remarks. It's at Supplementary Bundle, tab 15, page 84 is the key paragraphs. Page 86 is the key paragraphs. So start with paragraph 7. It said that the claimant shall in due course instead file a claim form with the CAT in accordance with Rule 30 of the CAT rules. My learned friend put a lot of emphasis on the word instead, but it doesn't help her. I'm going to go back to ducks. If the fact that you agree to accept a chicken instead of a duck to which you are otherwise entitled doesn't mean that when you get a chicken, you have a right to complain that it doesn't quack and can't swim. I mean, instead doesn't have the meaning that she wants it to mean. Put more generally, the fact that you agree to accept X instead of Y means, absent language to the contrary, that you accept X with all the features that you would normally expect to have X to have. So in this case, absent any language to the contrary, all that instead tells you is that the parties have agreed that there will be a claim form with all the claim form's inherent legal effects instead of a particulars of claim.
Yeah.
You might suggest it's a new initiation because it's instead.
Instead, yes. And that conclusion is strengthened by the provisions express reference to rules 30 and 31 of the CAT rules, references which are entirely unqualified by any provision that cuts back on the normal effect of those rules. Paragraph 9, mutual preservation of accrued rights. And our point is the short one, that in 9.2, the reference to accrued rights cannot mean a right not to have a claim brought against the defendants under Section 47 within the Section 47A, within the Section 47A window, because they had no such accrued rights. They had 2 years to go before they could breathe a sigh of relief and break open the champagne. The whole case law of which Merrick's and Ubontu are examples of case law on disturbing accrued limitation rights, cases where the champagne has been opened and drunk and then people are told you don't have that limitation defence that you thought you had, is all completely irrelevant. Here the champagne was never broken open. And on that note of a sigh of relief from breaking open champagne, I pass the baton to Mr. Drake.
Thank you very much, Mr. Parents. Mr. Drake.
Lords, I'm going to deal first with the point about D12.
Yeah.
Which is Sun Pharma UK Limited. And it's common ground that when the High Court claim form was issued on the 19th of June 2019, it didn't include D12 as a party. In order to see when D2 did become a party, one has to turn to the supplemental bundle, and my own friend Ms. Ford took you to this in the morning. Supplemental bundle, tab 26, page 121.
Yeah.
is cat order, which, if one turns over to page 123, at paragraph 1, gives permission for Sun Pharma UK to be added. And that order was dated the 14th of March. And if one turns over 2 pages to 125, page 125, one sees a letter from the claimant's then solicitors to the CAT registry, enclosing the amended claim form that included D12. And that's dated the 17th of March. So this is the moment when the claim against D12 is made. And, just state the obvious, this happens in the tribunal, not in the High Court. The next place to go and look is the rule itself, Rule 119, which obviously we've been through a lot today, but turning to it at Authorities Bundle tab 23, page 569, the critical provision is 119.2, and it says, and it's important when reading this to bear in mind the point that Ms. Ford was making this morning, which appeared to be that the limitation regime is to be decided on the basis of the proceedings as a whole, rather than on the basis of the individual cause of action or claim. But when one looks at sub-rule 2, it says that Rule 31, 1 to 3 of the 2003 rules, time limit for making a claim, continues to apply in respect of a claim, which falls within paragraph 3, that's not in dispute that it falls within paragraph 3, for the purposes of determining the limitation or prescriptive period which would apply in respect of the claim if it were to be made on or after the 1st of October 2015 in, and then you get the word proceedings, under section 47A of the 1998 Act. So in my submission, although it does refer to proceedings as the context in which the claim is made, it is a rule that triggers the application of a particular limitation regime on a claim-by-claim basis. And my lords, one goes from there to the Authorities Bundle at tab 17, page 527. And this is section 35 of the Limitation Act, which the appellants rely on. They say that relation back is relevant here. But if one has a look at section 35 and what it actually provides, it's section 35(1) that's relevant. For the purposes of this Act, any new claim made in the course of an action, and the claim against D12 is a new claim, shall be deemed to be a separate action and to have been commenced. We're not concerned with A, we're concerned with B, in the case of any other new claim on the same date as the original action. Section 35(1) is a deeming provision about timing, but it says nothing about forum. Says that the new claim is to be deemed to be a separate action commenced on the same date as the original action in which that claim is made. And in our submission, it is inescapable as a result that the claim against D12 is a claim that was first made in the tribunal, actually, in terms of real facts, it was made in March 2023. One can say that by virtue of the statutory deeming in section 35 of the Limitation Act, it was made, depending on what one wants to argue about, you could argue for the date of the claim form in the Competition Appeal Tribunal, which is the 28th of February 2023, or you could go for the High Court claim form, which is 19th June 2019. But in any event, both of those dates are after the 1st of October 2015. And 1st of October 2015 is the important date. If we go back to page 569 of the same bundle, the important date for Rule 119.2. Approached on a claim-by-claim basis, this is a claim that was made in the Competition Appeal Tribunal after the 1st of October 2015 in proceedings under section 1447A of the 1998 Act. And therefore we say it is a claim to which the Rule 31 time period applies, and it is a claim made within that time period because that time period expired on the 25th of March 2023.
The practical consequences, if you're right on this and Mr. Peretz is wrong on the rest, is that you continue to sue Sun and they bring everybody else back in by way of contribution proceedings.
Yeah.
That would be your tactic, at least.
Certainly continuing to sue D12, and then the extent of who's brought back in is a matter for them. But clearly that's the obvious implication of what happens. And admittedly, in respect of the infringement to which D12 is a party. But in our submission, it's simply impossible to understand on what basis D12 is participating in the present appeal. Because even on the appellant's construction of the rules, the claim against D12 is just a claim that was made in the CAT. It was never made in the High Court. And on any basis, it was made
Made within the 2-year period.
within the 2-year period.
End of point.
Certainly before the cut-off date of 25th March 2023.
Well, even if you looked at it in section 35 terms, by the time the claim's made, the High Court proceedings have been, whichever way you look at it, they're no longer in existence. They've either been effectively subsumed by these, if Mr. Peretz is right, effectively the new proceedings, or they've transmogrified into CAT proceedings.
But
So you don't go back to, the point I'm trying to make is you simply don't go back to 2019. I just don't see any basis for that at all.
No, even if you did, if the High Court proceedings had continued abusively in the High Court, and one chose to say, we'll use section 35 to deem the D12 claim to have been begun in 2019, it wouldn't mean that it was deemed to have been begun in the High Court. It started in reality in the CAT, and there's nothing in section 35 that says you have to deem something about the forum. The whole purpose
there wouldn't be
of
a time bar issue because the section 47A entitlement didn't arise until March of 21, because the relevant appeal to the European Court wasn't, the final appeal wasn't until March 21. That's when the 2-year time limit started running.
Yes, well, the Rule 31 time period, 2-year time period,
Yeah,
has, as it were, a hard end date and,
yeah.
if I can say, a soft start date, in that if you are too
You can
early to the
start
start
earlier,
date, you
yeah.
have to ask for
Yeah.
permission. But that's not the same as your claim failing because it's time
It's not
barred.
the same as saying you have to do that. That's the point, isn't it?
Yes, the consequences aren't the same. If you miss your limitation period, your claim is disposed of summarily or at trial.
Yeah.
But if one proceeds too early in terms of the Rule 31 time period, you have to ask for permission from the CAT and live with what it says, subject to appeal.
The whole point of relation back normally is to avoid limitation defences. And it's somehow being said here that relation back creates a limitation defence where none would otherwise exist. And it seems to be because what is relied upon is not relation back in terms of time, but in relation back in terms of somehow fictionally making them party to the High Court proceedings, which therefore loops them into this problem that the commencement of the claim against them in the CAT it isn't actually a new claim.
Yes, you're following it backwards down the pipes to see where it originally came from. But that just isn't what Section 35 says. Section
That's
35
not
just
what
says
relation back is all about.
no.
No.
The Limitation Act is fundamentally often about the computation of time.
Mm. Yeah. Okay.
My Lord, so that's what we say about the 12th defendant. As far as the other respondents' notice point is concerned, that is our alternative construction argument. My Lords, you've heard a lot about the construction of the rules already. It's set out fully in our skeleton argument. I won't elaborate the points any further when they are, as I said, advanced as an alternative to our primary case.
Okay. Thank you very much. Thank you, Mr. Drake.
Some very brief points in reply.
Yeah.
It was suggested that the claim before the CAT was somehow a different claim than the claim that was originally brought before the High Court. In that context, I'd just like to show the court some correspondence which happened very early on, which we haven't been shown to date, behind tab 3 of the supplemental bundle.
Yeah.
The court will see this as a letter dating 4th of July 2014. And in relation to that, what is essentially being flagged at, even at this very early stage, is put you on notice of the NHS's intention to commence a follow-on claim against you in the High Court of England and Wales following the decision of the European Commission. So even at this very early stage, the claim is being characterised as potentially a follow-on one based on the European Commission decision. The next point, the next way in which it was suggested that this is somehow a different claim was to say, well, when it comes to the CAT, it's made as a Section 47A claim, and it was said that is incontestably a different claim. To the extent that Section 47A is concerned with the jurisdiction of the CAT to hear claims and not the jurisdiction of the High Court to hear claims, of course, that is right to that very limited extent. It cannot apply in the High Court because it's not concerned with the High Court's jurisdiction. But in our submission, the claim itself is not substantively different. It is the same claim which is being pursued before the High Court and which is then pursued before the CAT. It was then suggested that the correct characterisation of our case is that the claim form that was issued under Rule 30 in the CAT doesn't count, and our case was characterised as being it doesn't count for reasons which have to do with the background history and or the party's subjective understanding. I'm hoping that the court has well in mind that that is not the submission I'm making. The submission I make is based on an objective construction, we say, of what is meant by the word make in the rules. It is not a submission that turns either on background history or the party's subjective understanding of what was going on. It was then submitted that the claimants are not seeking to resurrect a time-barred claim, and it was suggested that in fact they were making exactly the new claim that it's conceded they were entitled to make, and it was even the case was even taken so far as to suggest that this might be a potentially duplicative claim that was being brought. I simply reiterate that that is not what the tribunal found was going on here, and I do rely on its characterisation of the position in paragraphs 43, 45 and 46 of its judgment, where it was very clear that this was not bringing a new claim, this was the transfer of an existing claim. And in that respect, that is entirely consistent in my submission with the point my Lord Justice Phillips made about the existence of one claim number indicating the existence of one claim. That is consistent with the way in which the CAT has analysed the matter as well. Your Lordships were shown Deutsche Bahn, in which a new claim had been issued for protective reasons in order to preserve the position as a matter of limitation. That, in our submission, is what these claimants should have done. They should have started a new claim had they wished to take advantage of the limitation period in the CAT, and that is, in our submission, what they did not do. It was then suggested that I have not indicated what I say is the missing ingredient in the claim form that was issued under Rule 30 of the CAT rules. I do not suggest that there is a missing ingredient. The submission I make is that you cannot make the same claim a second time. Now, it's beyond dispute that one can make a different claim, and the example was given of a vexatious litigant who issues multiple successive claims. That, in our submission, is very different than the circumstances of this claim, where there was a single claim made and that was transferred from one venue to another. There was also an exchange with the court concerning what might be the irregularity that the CAT might seek to rectify in the circumstances of this case. In my submission, there was no irregularity here. This was a conscious decision on the part of these claimants to continue with proceedings that were already on foot, rather than to bring a new claim. Just to be clear, I certainly don't suggest that it all comes down to whether or not the T should have been left off on the claim form. In my submission, the presence of the T on the claim form is indicative of a much broader issue, which is this is not properly analysed a new claim that was brought. It comes back to what we say is a very narrow point of construction. We say it is not a claim which is made under section 47A on a proper construction of the rules. My Lords, unless I can assist further, that's my reply.
Just turning the prior point around, that it was a conscious decision to continue an old claim, and that's not an irregularity. Might it be said the irregularity is continuing with that old claim under the guise of Rule 30 without abandoning the old claim? Is that an irregularity?
I'm not sure old claim is quite the
claim.
character. An existing claim. It's not merely an irregularity. It is a conscious decision that was made in circumstances where, as the CAT has found, the claim that was continued and that was transferred was subject to accrued limitation rights of my client. In my submission, that is not an irregularity. It is a conscious decision taken for whatever reason. And the Deutsche Bahn case to which your Lordships were then taken is illustrative of the alternative that could have been taken but wasn't.
Yeah.
Thank you very much.
Stephen? Well, thank you all very much indeed. Thank you for your helpful submissions. We heard from Mr. Drake anyway, but we're conscious that these things are all teamwork, not just the applicants, but also solicitors as well. Thank you very much for dealing with the case well within the time limit in a constructive and helpful way. We're obviously going to reserve our judgment. We'll let you have something as soon as we can, but no promises it'll be this side of Easter, given that we've now only got just over 3 weeks before the Easter vacation, not the long vacation. When you get the judgment in draft, please note the terms of the embargo and make sure that you comply with it. And when you'll be invited to provide us with typographical and similar errors, which is exactly what it says. It's not an opportunity to invite the court to reconsider its decision. Even though I say that in every single appeal that I preside over, there are occasions when people have a try anyway, but please resist the temptation. But anyway, thank you all very much indeed, and when the time comes, have a good break and a good vacation.
All rise if able.